All right, so today we're going to pick up with the topic on criminal justice that we actually began last week, although we did so by way of the video recorded program, the Constitution, that Delicate Balance, that roundtable program. If you were here last week, you remember that we watched that. That took pretty much the entire class meeting. Um, you know, Obviously, that program, the panelists in that program really didn't talk about the Texas criminal justice system. In fact, they were focused mainly on uh, provisions of the United States Constitution that were relevant to criminal justice. And even more specifically, they focused on something called the exclusionary rule that we're going to elaborate on in today's class session. But the reason I showed you that program in part is because it's really very difficult for us to make much sense out of the criminal justice system in Texas apart from the um, uh, the United States Constitution. Texas is not exempted from the provisions of the United States Constitution. Therefore, we're going to continue that emphasis on provisions of the United States Constitution in our treatment this week, both in today's class session and in the Thursday class session that will be recorded for you. Um, and we're going to elaborate a little bit on some of the points that were made in that program and update. A good chunk of our effort this week is going to be in the Tuesday class session and the Thursday class session to update some of the things that they talked about in that program, because you remember that program is pretty old. That was recorded back in the mid 1980s, and so 40 years ago, a lot has happened in the area of criminal justice since then. So we're going to make our best effort to try to update some of that. Um, Let me begin though with the Constitution, and remind you of some of the provisions that are relevant to this. Let me make sure I'm. Why is this not showing correctly? Let's see. Yeah, I think that's right. So again, just to review the relevant provisions of the Constitution to this discussion on criminal justice. The Fourth Amendment, I tell you what, let's actually look at the verbiage of the provisions themselves. The Fourth Amendment says the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause. Make note of that part right there. No warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized. Also make a note of that part, because we're going to come back here in just a bit and talk about the implications of that part of it. But going back to this point about probable cause, what does that refer to? Somebody explain that for the benefit of your classmates, what we mean by probable cause. So when the police go to a judge and ask for a warrant to search a person's home or some private place, they have to establish probable cause. What does that mean? Anybody in here studying criminal justice? Anybody in here thinking about a career in law enforcement? Anybody in here want to go to law school, practice law afterwards? No. What are you going to do? And we'll talk about that later. Any guesses what that means, probable cause? Okay, so the police have to provide some sort of evidence to the judge who is got to make the decision about whether or not to issue the warrant. And presumably they've got to provide enough evidence that they're going to find what they say they're going to find when they conduct the search. And the judge has to make the determination, right, whether there is probable cause. So if the judge determines that there's not sufficient reason to believe that they're going to find what they say they're going to find, unless the judge is a rubber stamp for the police, which we presume that judges are not supposed to be. They're supposed to be neutral magistrates, right? The judge would not sign off on the warrant. But if the judge is satisfied that there's a high probability the police will in fact find what they say they're going to find, then we'll issue the warrant. Okay? So yeah, that's the Fourth Amendment. The Fourth Amendment is very relevant to all this business that we're going to be talking about today. The Fifth Amendment, there's a lot in the Fifth Amendment, kind of like the First Amendment. The First Amendment has the religion clauses in it. It has the speech clause. It has the freedom of the press clause. It has the right to peaceably assemble and the right to petition government for redress of grievances. So there's about a half dozen provisions of the First Amendment. The Fifth Amendment is kind of like that. Those could all be broken out into separate articles, I suppose, right? In which case we wouldn't be talking about the Bill of Rights as the first 10 amendments of the Constitution. We'd be talking about the Bill of Rights as the first 16 or 17 amendments, something like that. Anyway, they're all put there in the First Amendment together. And as I said, the Fifth Amendment is kind of like that because you can see the verbiage up there. There's a lot of stuff in there. The part that we're interested in is that part that says, nor shall any person be compelled in any criminal case to be a witness against himself. The provision against self-incrimination, which most people, you don't have to take a law school course or even an introductory government course. I think most people in our society are familiar with the phrase, taking the fifth, right? If you've seen enough television cop shows or movies that involve criminal, procedural matters, then invariably you get, some accused person availing them of their right under the Fifth Amendment, taking the Fifth Amendment, not the right not to incriminate themselves, not to say anything that would be incriminating. Okay. Next is the Sixth Amendment. The next one that's relevant for our discussion today is the Sixth Amendment. And again, there's several things here, but the part that we're mainly interested in, two things here actually, the business about a speedy, public, and impartial trial. And then down there at the bottom, the right to counsel. On that first part, let me just digress here for a moment and make a point that I've discovered over many years really needs to be made. You may already be aware of this, but whose right is it to a speedy trial? The Sixth Amendment here embraces the right or articulates the right to a speedy trial. Whose right is it to a speedy trial? Is it the government's right to a speedy trial? Is it society's right to a speedy trial? The person who's accused has the right to a speedy trial. The reason I think this is an important point to make is because I hear people quite frequently, in frustration sometimes with the criminal justice system, say, well, why is it taking so long for this case to go to trial? Why hasn't this person already been put on trial? Better yet, why hasn't this person already been convicted and put away? Right? Particularly people who are convinced they know the outcome or what the outcome of a trial should be before the trial, ever occurs. But maybe you've heard people make that argument before that, like it seems like a lot of these criminal cases, it takes a year or 18 months or 2 years for the case to ever go to trial. And people wonder out loud, oftentimes, whatever happened to the idea of a speedy trial? Well, my response to that is, if you care to know my response, is it's the defendant's right to a speedy trial. It's not society's right to a speedy trial. So what is the philosophical motivation of the framers of the Bill of Rights? Remember, these words were written way back in 1789. Right? So what was their motivation for protecting the right of an accused person to a speedy trial? What's the danger if that right's not protected? Can you think of any dangers to a society of free people that might exist if this right to a speedy trial is not protected? Is there any danger, for example, that government might just arrest people and never bring them to trial, right? Or take a very, very long time to bring them to trial? So it is really a protection against abuses of prosecutorial authority by government, right? So anyway, I just wanted to remind you of that point because it is one that I think many Americans really confuse. It's not the right of society to a speedy trial. It's not the right of the government to a speedy trial. It's the right of the accused to a speedy trial. Okay. Next is probably won't get to it until Thursday's class, but is the Eighth Amendment, and that's the provision specifically. We'll be interested in our discussion of the death penalty in the Thursday class meeting against cruel and unusual punishments. Okay. So again, that'll be for you guys. That'll be in the form of a recorded class session. Okay. All right. So, any questions about these amendments? Just the verbiage in these amendments. Fourth Amendment, Fifth Amendment, Sixth Amendment, and then eventually we're going to get to the Eighth Amendment. The Fourth Amendment provision against unreasonable searches and seizures and the requirement of search warrants, the Fifth Amendment provision against self-incrimination, Sixth Amendment right to counsel and right to speedy, public, and impartial trial, and the Eighth Amendment provision against cruel and unusual punishments. Now, there's one other provision of the Constitution that we absolutely must touch on, which you just took a quiz, and one of the items on that quiz was really sort of getting at this. And even though in that program you watched last week, they did not talk about this directly, there was no specific mention of the 14th Amendment per se. I think there was some reference to it, but that was a question on the quiz that was really asking you to sort of think a little bit and deduce an answer, okay? Because certainly there was enough discussion in that video that you watched that if you had watched it thoughtfully, it should have occurred to you that most of the cases that we talk about in the area of criminal justice really fall under the authority of states. So what does the provisions of the Bill of Rights have to do with the states? Right? It's a very important question, and we have to address that a little bit. So let's look at the language of the 14th Amendment together. This is kind of a significant digression that we need to go into here. So please be patient with me, but I think it's an important thing for us to understand as we move forward with this discussion. Okay. So there's 5 sections of the 14th Amendment. We're just interested in section 1. In fact, we're interested in really right now just part of section 1. But let's go ahead and look at the rest of it. We've talked about the 14th Amendment in this class previously. Okay, I don't know if you remember back when we were talking about voting rights and specifically the effort to, on the part of some states, to restrict access to voting on the part of African Americans and particularly, but other segments of society as well. Okay, you'll remember that the 14th Amendment, together with the 13th Amendment and the 15th Amendment, we take those 3 together, we call them the Civil War Amendments. They're often referred to as the Civil War Amendments because they were passed in the years immediately following the Civil War. The 13th Amendment in 1865 prohibited slavery in the United States. The 15th Amendment added to the Constitution in 1870 prohibited denial of the right to vote on the basis of race, creed, color, or previous condition of servitude. And the 14th Amendment that we're looking at here was added in 1868. So there's several things here. First of all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. Now, again, this is something we've talked about previously, so maybe someone remembers why we said this was important language that was inserted into the Constitution after the Civil War. What does this language really accomplish? This first sentence, all persons born or naturalized in the United States are citizens of the United States. Well, let me ask you this question first. Who, got to sort of think about what was happening in the years immediately following the Civil War, okay? Who might the framers of the 14th Amendment whose welfare might they have been preoccupied with? These words were written or added to the Constitution in 1868, a few years after the conclusion of the Civil War. Who might the authors of these words, the people who are responsible for these words, who might they have been concerned about? Whose welfare might they have been concerned about? No thoughts there at all.
African Americans.
Yeah, former slaves. Right? I don't think there's any question. It's pretty clear in the historical record that they're principally concerned about the rights and the welfare of African Americans. Remember, slavery was abolished by the 14th Amendment, by the 13th Amendment in 1865. So we're only 3 years later, right? And they're establishing in the Constitution, by constitutional provision, that any person born in the United States, understand that most African Americans at this time would have been born in the United States. The slave trade ended. Africans had not been imported to the shores of the United States for decades. So most of these former slaves would have been born in the United States. What does the word naturalized mean? You know that process that immigrants go through to become U.S. citizens? It's called naturalization. Right? So this is establishing that any person born in the United States or any person who's naturalized in the United States, and by the way, I think that, just to digress a little step further here, I think it's important for us to recognize that that means that persons who immigrate to the United States and become citizens through the immigration or through the naturalization process are just as much American citizens as people who are born here. There's no special status to birthright citizenship. Born in the United States, naturalized as a citizen of the United States are equivalencies. Well, the framers of the 14th Amendment in the 1860s weren't as much concerned about that as they are about in the present for them as they were for the former slaves. Okay? So the real significance of this language is to establish that if you're born or naturalized in the United States, you are a citizen of the United States first and foremost, and therefore a citizen of the state wherein you reside. You see, up until that point, the states essentially determined who was a citizen or who wasn't a citizen. And if the states could determine who's a citizen and who's not a citizen, the states could effectively determine who has citizenship rights and who doesn't have citizenship rights. So if you're born in the United States, or if you're naturalized as a citizen of the United States, you are a citizen of the United States and of Texas if you happen to reside in Texas. And if you pick up and move from Texas to Massachusetts, you are also still a citizen of the United States and therefore a citizen of the state of Massachusetts. You see why that's an important provision of the Constitution to add in 1868? Okay? Again, it's not the main one that we're interested in here, but I think it's important to hammer that point home. Okay? No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. This is the so-called Privileges and Immunities Clause. But again, it's not the one that we're mainly concerned about here. It's actually this next one that says, nor shall any state deprive any person of life, liberty, or property without due process of law. This is the very, very important, as it relates to criminal due process. This is the very, very important this is the very important due process clause of the 14th Amendment. So if you're writing anything at all down, you might want to jot down 14th Amendment due process clause. That's the part of it that we're interested in. You also see there the so-called equal protection clause that follows it, but we've dealt with that one previously. Okay? Nor shall any state deprive any person within its jurisdiction of equal protection of the laws. Okay? So this 14th Amendment due process clause. So this part of it is pretty straightforward, right? Nor shall any state, that means Texas or Massachusetts or California or Oregon or Virginia or any other state. You can substitute any state's name in there and it applies. Nor shall Texas deprive any person of life, liberty, or property without due process of law. Nor shall Virginia deny any person due process of law. Okay? This term right here is really the key term, liberty. Okay? Nor shall any state deprive any person of liberty without due process of law. The question now is, well, what does the term liberty include, or what does it incorporate? And that question has, the answer to that question has really devolved to the United States Supreme Court. Okay? The courts in general, but specifically the United States Supreme Court. Now, you have to understand that the Bill of Rights and the civil liberties rights that are therein enshrined were written in, those words in the Bill of Rights were written in 1789. Remember, the Constitution was written in 1787, and it was submitted to the states for ratification. It was ratified and took effect in 1789, and when the first Congress met in 1789, it drafted 12 articles, submitted those articles to the states. 10 of those 12 articles were ratified and became what we call the Bill of Rights, the first 10 amendments of the Constitution. So when those words were written, those provisions that we call the Bill of Rights, when they were written, there was a prevailing understanding of who or what they restricted. Right? In fact, you can see here this phrase that says, Congress shall make no law. That's the phrase that opens the Bill of Rights. In the First Amendment of the Constitution says, Congress shall make no law respecting an establishment of religion. And you're supposed to understand that that phrase, Congress shall make no law, is implied with each successive provision of the Bill of Rights. Okay? Congress shall make no law respecting an establishment of religion. Congress shall make no law prohibiting the free exercise of religion. Congress shall make no law abridging the freedom of speech. Congress shall make no law abridging the freedom of the press. Congress shall make no law abridging the right of the people peaceably to assemble. Congress shall make no law abridging the right of the people to petition government for redress of grievances. That's just the First Amendment. But then as we go to the Second Amendment, who knows what's in the Second Amendment? The right to keep and bear arms. You're supposed to understand, though, that that phrase, Congress shall make no law, is implied. Congress shall make no law abridging the right of the people to keep and bear arms. And when you go to the Fourth Amendment, the right of the, to be secure in your person, houses, papers, and effects against unreasonable searches and seizures, you're supposed to understand that that phrase, Congress shall make no law, is implied. Congress shall make no law abridging the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. So do you understand the point that I'm making to you, that the historical intent of the Bill of Rights was to limit the authority of the national government? It was not to limit the authority of the states. It doesn't say there, Congress and the states shall make no law respecting an establishment of religion. So that's a very key point that you really have to understand, that the Bill of Rights, in its original intent, in its original purpose, was to limit the power of the national government to abridge the rights and liberties of citizens. Now, why is that so important for us in this discussion of criminal justice? Well, because most of criminal law falls under the jurisdiction of state authority, right? Most laws, most criminal laws are really written by states or their local subdivisions. So laws against murder, laws against theft, laws against burglary, the penal code, as it's called, right? That falls under what is commonly referred to as the state police power. The state police power means the power of the state to protect public safety and morals. So the fact that most criminal law, there are federal criminal laws, right? If someone robs a bank, okay, and they are apprehended and put on trial, that's going to be heard in a federal district court because it's a violation of federal law. If the DEA is pursuing a drug trafficker, right, and they, bust the guy for drug trafficking, there's really probably a pretty good chance that that case is going to be heard in federal court because it's a matter of federal law. Kidnapping, I think, is also another example, right? That's a violation of federal law. So any trial, put somebody on trial for kidnapping charges, that's going to be heard in federal court. But those are exceptions. That's not the rule. The rule is that most criminal cases fall under state law, under the state police power. So the question of whether or not you have a right against unreasonable searches and seizures in the course of a criminal investigation, do state law enforcement officers, do local law enforcement officers have to get a search warrant before they come and search your home? Do you have a right not to incriminate yourself? That's a question that for most criminal defendants is going to be put to the test because they're being questioned by state or local law enforcement agencies, officers. You understand what I'm saying? So this point here about the Bill of Rights and how it came to be understood as a protection against state authority and not just a protection against federal authority as it was originally intended is an important question. And that's why we're digressing on this point somewhat, okay? So here's the quick explanation. The 14th Amendment was added to the Constitution when? Just told you a few minutes ago. When was the 14th Amendment added to the Constitution? 1868. Good. Thank you for answering. Okay. The 14th Amendment was added until 1868. And what does it say? The part that we're interested in, it says, nor shall any state deprive any person of life, liberty, or property without due process of law. But it wasn't an immediate thing. It's not like immediately in 1868 that became a relevant provision of the Constitution. It actually took almost a half a century, or just about a half a century, for the United States Supreme Court to begin applying it at all. It wasn't until the early part of the 20th century, beginning with the right of free worship and the right of free speech, where the United States Supreme Court really began to ask the question, is the right of free speech a fundamental civil liberties right of the individual? And if so, does the 14th Amendment due process clause protect that right of the individual against the authority of the state? Well, in the cases of the right of free worship and the right of free speech, the Supreme Court said in the early part of the 20th century that it is a fundamental right of the individual. The right of free speech is a fundamental right of the individual. So therefore, not only does the First Amendment mean that Congress shall make no law abridging the freedom of speech, it also means that state legislatures and city councils shall make no law abridging the freedom of speech. Even though it just says Congress. Through the 14th Amendment, it also means the states and their local subdivisions. Does that make sense? With the right of free worship, it doesn't just mean that Congress shall make no law respecting the establishment of religion or prohibiting the free exercise of religion. It also means state legislatures and city councils and other state and local authorities cannot establish religious practices and can't prohibit religious free exercise. If we fast forward almost an entire century, we could take the Second Amendment as an example, the right to keep and bear arms, because it wasn't until 2010, that was about 12 years ago, that the Supreme Court said for the first time that the right to keep and bear arms is a fundamental right of the individual. And so the Second Amendment, which says Congress shall make no law abridging the right of the people to keep and bear arms, although remember that phrase, Congress shall make no law, is implied, right? But not only does it mean Congress can't abridge the right to keep and bear arms, it also means that state governments and local governments, because the right to keep and bear arms is incorporated into this concept of liberty. Is the right to keep and bear arms a fundamental civil liberties right of individuals? The Supreme Court says now, yes, it is. Well, it really wasn't until the middle part of the 20th century that we began getting into the criminal justice questions, like the Fourth Amendment, right against unreasonable searches and seizures, and the requirement of the search warrant, or the self-incrimination issue, or the right to counsel issue, okay? So beginning about, the middle part of the 20th century, we get a series of court decisions that, if we take them all together, we're going to talk about some of them individually, but if we take them all together, the general, outcome of these court decisions in the middle part of the 20th century is that these protections in the Bill of Rights are also protected against state authority. Okay, so that's why the 14th Amendment due process clause is so important. Okay, you don't have to transcribe all of this detailed information that you see on the screen. Okay, I think it's sufficient for our purposes for you to understand that the 14th Amendment, what part of the 14th Amendment? The due process clause. Thank you for chiming in. The 14th Amendment due process, because remember, there's other stuff in the 14th Amendment, right? So the 14th Amendment due process clause is the part of the Constitution that has been so important in applying things like right to counsel and right against self-incrimination and right against unreasonable searches and seizures against state and local law enforcement. And that's where it's at in terms of criminal justice, right? That's where criminal justice is administered and executed for the most part. Okay, any questions about that? It's called the doctrine of selective incorporation, and I do understand that this is not a law school course, but believe me, it's not just Fagan introducing you to this. Most introductory American government textbooks introduce students to the doctrine of selective incorporation, because it is almost impossible to understand, for example, many areas, including this area of criminal justice, without some basic understanding of the doctrine of selective incorporation. Why is it not the doctrine of total incorporation? Well, because there's never been a time where the Supreme Court has said everything in the Bill of Rights is a fundamental civil liberties right and therefore protected against the authority of the states through the 14th Amendment due process clause. It's done it selectively on a case-by-case basis. As I said, beginning in the early part of the 20th century with the right of free worship and the right of free speech. And then we get to the middle part of the 20th century and the criminal due process rights, like the right against unreasonable searches and seizures and the search warrant requirement and all that kind of stuff comes in the middle part of the 20th century. We get down to the end of the 20th century, or certainly the early part of the 21st century, and we're dealing with some of the remaining ones, like the right to keep and bear arms. So it's taken a century for the Supreme Court to incorporate those provisions of the Bill of Rights that it has incorporated to date. Never done it just all at once. Now, there's one other general issue that I think we all need to understand is before we get into any of this case law. It's really not possible also to understand much about what happens in the criminal justice system unless we talk about some case law, okay? So before we get to the case law, there's one other issue here that we need to be aware of, and it's what I refer to as the issue of line drawing. Okay? The fact of the matter is that that's really what law is about. The application of law by courts is really about line drawing. Because as much as we might like for things to be black and white, and that's, I've discovered over many years of doing my job that really seems to be a characteristic of the students who come into my classes, not to the person, but a large percentage of the students who come into my classes. It's like, just tell me what it is. Is it this or is it that? You know? Well, the law is much more nuanced than that. And I probably would like for it to be this or that just as much as you would. But the real world, at least in the part of the world that we're talking about here, just isn't that straightforward. It isn't that simple. It's always a matter of line drawing. And the reason that it's a matter of line drawing is because none of these civil liberties rights have ever been understood to be absolute. You don't have an absolute right of free speech. You can't say anything you want to, anytime you want to, under any circumstances that you want to, and have the protection of the First Amendment. I mean, and there are some obvious illustrations of that, right? And if I've mentioned this to you previously in this course, I apologize for repeating it, but I can't think of a better way to illustrate it. You cannot get in a pickup truck and drive around a residential neighborhood at 4 a.m. blaring some message over a public address system, waking up all the neighbors and whipping all the dogs into a frenzy. And when the police come and slap you with a citation for disturbing the peace, say, oh, hold on a second, I've got a right under the First Amendment to free speech. And by the way, I've taken Fagan's government class, and I know that that's protected against the authority of the state of Texas and therefore the city of Sugar Land, through the 14th Amendment due process law. Well, you can make that argument all you want, but you're not going to prevail. Because our society has always recognized that we can place, at a minimum, reasonable time, manner, and place restrictions on speech. You can't walk through town center down here in Sugar Land uttering all kinds of obscenities, and when the police come and slap you with a citation for violating local obscenity law, say, oh, I've got a right under the First Amendment, because we have never recognized as a society that obscenity is protected speech. Fighting words is not protected speech. Libel and slander are not protected speech. So you can't say anything you want to, anytime you want to, under any circumstance. By the same token, the right of free worship is not absolute. Again, obvious example. You can't practice human sacrifice. And when the police come and charge you with murder, say, oh, my religion requires that we sacrifice virgins. Right? Well, again, you can make that argument, but you're not going to prevail, right? I would think that the right to keep and bear arms is also a matter of line drawing. It may be that it's too new, it's too fresh for the lines to be sorted out very well. But if what we're saying as a society is that we're going to place reasonable time, manner, and place restrictions on speech because the community has an interest of, a certain amount of peace at night, that's the community interest, right? That people need to sleep, and you can't, interrupt that public peace with your messages, or, people have a right to not be sacrificed in the name of your religion, right? There's a community interest there. I don't know why we wouldn't be able to say the same thing about the right to keep and bear arms. If the government wants to say, well, we want to ban hollow point bullets, is that a thing? Hollow point bullets? We want to ban those because the carnage that results is particularly invidious. Then I don't really know why we would somehow think that the right to keep and bear arms is sacrosanct, that it's any more absolute than the right of free speech or the right of free worship or any of these other civil liberties rights. You follow what I'm saying? So it's always a matter of line drawing. So as we talk about these criminal due process issues, maybe keep that in mind, that what we're really talking about here is where does the court draw the line between, in this particular case, where's the court draw the line between the right of the individual on the one hand, whether we're talking about the right against unreasonable searches and seizures, or the right against self-incrimination, or the right to counsel, what have you, okay? But it would also apply in those other civil liberties areas that we're talking about: right of free speech, right of free worship, right to keep and bear arms, etc. Okay? So the right of the individual on the one hand versus the interests of the state, and I'm using the term state here very generally to mean the community, the authoritative arm of the community, the state, right? And as I indicate there, those arguments generally fall under the umbrella of the state police power, the authority of the state to protect public safety and morals. But notice that I've indicated there with the asterisks that when we talk about these civil liberties issues, it is generally incumbent upon the state to establish why the interest that they are asserting is compelling. And that's the question that the court, the basic question that the court is going to ask. Is this effort on the part of the state to restrict this person's free speech rights? Is this effort on the part of the state to restrict this person's right of free worship? Is the effort on the part of the state to restrict this person's right to keep and bear arms, or whatever the civil liberties right is it compelling enough? Is the state's interest compelling enough to justify intrusion or restriction of that person's right? Okay, so as nice as it might be, as we talk about, right to counsel, as we talk about the right against unreasonable searches and seizures, the right against, as nice as it might be to say that there's a bright line that the court has drawn and it's fixed in all time, in all cases, and this is where the lines, it just doesn't work that way. And I think as we go through some of the case law, that will be hopefully become a little bit clearer. Okay? Questions about those points? Well, so with all of that in mind, let's talk a little bit about the exclusionary rule, because that was the main issue that the participants in that roundtable discussion program that you watched last time were talking about. Okay, so refresh our memories what the exclusionary rule is. The exclusionary rule is a court-developed rule that says that evidence that's obtained by law enforcement in violation of the Fourth Amendment's guarantee against unreasonable searches and seizures cannot be used at trial to obtain a conviction against the defendant. That's something that you should already have some understanding of based on the program that you watched. But just to get it down, in a very concise, or at least as concise as possible way, that's about the best I can do for you in terms of just a basic description of the exclusionary rule. You may remember that one of the participants in that program was former Associate Justice Potter Stewart. And he referred at a couple of points during that program to a decision of the Supreme Court. He said that was decided almost 70 years ago. But remember, that program was produced in the middle 1980s. So now we're talking about over 100 years ago. In fact, almost 110 years ago. The case he was talking about is this one, Weeks versus the United States. 1914 decision of the United States Supreme Court. That was the first instance of the first application of the exclusionary rule. And we don't have to get into the details of that case. It is a lot of these cases are pretty interesting, and you might want to go out and Google it if you're interested. It's a case involved, if I remember correctly, a man by the name of Vermont Weeks who was selling lottery tickets through the mail, which was a violation of federal law. And he was arrested and prosecuted. The federal law enforcement officers, I don't know what maybe it was like Postal Service inspectors or something, came to his home and seized a bunch of evidence. And he argued that his conviction should be reversed because they didn't serve a proper warrant in violation of the Fourth Amendment. And while the Supreme Court, if I remember correctly, upheld his conviction, they did hold that the evidence should not have been admitted at trial, should have been suppressed at trial. And so this is the birth of the exclusionary rule. Okay? Now it's important to know about that case also that it involved federal law enforcement. So there's no question the Fourth Amendment applies, right? Because what's the original intent of the Bill of Rights, including the Fourth Amendment? To impose restrictions on the federal government. The real issue then becomes, is the exclusionary rule applicable at the state and local level when we're talking about criminal cases that arise under state authority? That question really was not answered affirmatively by the Supreme Court until some decades later. It wasn't until this case, 1961, Mapp versus Ohio. This is the first time that the Supreme Court says that evidence obtained by state and local law enforcement officers in violation of the Fourth Amendment's requirement for search warrants, for a valid search warrant, cannot be admitted at trial as evidence. The case itself is very interesting. It involved a woman by the name of Doree Mapp, one of the large cities in Ohio. I'm not sure, for some reason I think it was Columbus, but it could have been Cincinnati or Cleveland or something, but it doesn't really matter. Police came to her home with a search warrant that specified that they were looking for evidence in a bombing incident, evidence in a suspect in a bombing incident. And they served the warrant and searched her home, and they didn't find any evidence related to the bombing incident, but they did find materials that they deemed to be obscene, pornographic materials, violation in their judgment of state obscenity laws. And she was put on trial and she was convicted. And she argued on appeal that the warrant didn't specify that they were looking for evidence in obscenity matters. They were looking for evidence in a bombing incident. And so the Supreme Court says that it should have been excluded at trial. It was an invalid search warrant. So this is the first time that the Supreme Court, as I say, applies the exclusionary rule to state and local. All right? Questions about Mapp? I'm going to try to keep these descriptions of these cases as simple as I can. But if you have questions, I can try to answer. I'm certainly not an expert on the details of these cases, but if you have something, throw it out there. Well, a couple of other things here that we need to be aware of. As an extension of the exclusionary rule, you have the development of this fruits of the poisonous tree doctrine. Now, the two cases that I have cited down here go back to the 1920s and the 1930s, but really the relevant case law pertaining to state and local law enforcement, we're talking about the 1940s, the 1950s, and the 1960s, okay? Perhaps into the 1970s. This doctrine says that when a judge suppresses physical evidence or statements because it was obtained by law enforcement improperly. In other words, there's something wrong with the search warrant. There's either no search warrant or there's something wrong with the search warrant, if we're talking about physical evidence, or if we're talking about statements, if Miranda is not administered properly, okay? If that evidence is suppressed, then any subsequent evidence that the police find may be suppressed as well if the judge determines that it was the direct result of the police actions that led to the original evidence being suppressed. Called the fruits of the poisonous tree doctrine. I've given a little example here. Suppose the police interrogate a suspect without properly administering the Miranda warnings. The suspect confesses to the crime and tells the police where he has hidden physical evidence. It's pretty clear that the statements are going to be suppressed at trial, right? If they don't administer Miranda. But now the question is, well, what he told in the course of this confession to the police, he told them where the physical evidence was, the knife or whatever, the weapon was. And the police go and search. They go to a judge and get a search warrant. Okay. But they didn't know about the physical evidence without the confession. And since the confession is not admissible, then the fruits of the poisonous tree doctrine says that the physical evidence is not going to be admissible as well. Okay? Questions about that? I don't know if that's the best example, but it serves. Well, before we get into some of the exceptions to the exclusionary rule, because that's really kind of where that program ended up. Remember the footnote? I let the footnote play. And the voiceover said that in the time between that program, that discussion being recorded, and post-production, or certainly before it goes to air, the Supreme Court handed down several important decisions. Up until 1984, the general thrust of the court's decisions, certainly going back to the middle part of the 20th century, from about the middle part of the 20th century down to the mid-1980s, we've got about 25 or 30 years where the decisions of the Supreme Court as they pertain to criminal justice tend to favor the rights of the accused. Right? I'll say that again because I think that's an important point. Okay? There's a period of time from the middle part of the 20th century down to the middle 1980s where if you take all of the Supreme Court's decisions together that deal with the rights of the accused, the general drift is to broaden the rights of the accused, to enhance the rights of the accused. So this is the period where you get, the exclusionary rule applied to state and local law enforcement. It's the period where you get the right to counsel cases that we're going to talk about. It's the period where you get the Miranda decision in 1966, for example, that we've alluded to several times, but haven't talked about it systematically yet. Okay. So in the 1950s, the 1960s, the 1970s, up until the mid-1980s, the general drift, think about it, I like to describe it sort of as a pendulum, right? Where through this period, the pendulum is shifting in favor of the rights of the accused. And by the way, something else is occurring during this period as well with respect to crime in this country. Middle part of the 20th century, through the 1970s and into the 1980s, it appeared to many Americans that crime was spiraling out of control. If you go back, for example, to the late 1960s and the 1970s and look at surveys, public opinion polls, where pollsters are asking Americans, what is the number one problem facing this country? They consistently showed that crime was the number one problem. If you were to ask people today, what's the number one problem facing this country? It wouldn't be crime. By the way, does anybody have any sense? Let's just talk about one crime. Let's talk about murders. Okay? Does anybody have a sense, like, how many murders are committed annually in the city of Houston? Just throw a number out there. The worst thing that can happen is you could be wrong. So somebody just throw a number out there. How many murders do you think were committed in the city of Houston in 2021? Say again?
300.
300? Okay, anybody else think that? We can, again, do that Price is Right thing, right? Higher, lower, higher, right? Which one? How many of you think higher? What do you think? 450, did you already look it up? No? That's pretty close, I think, actually. Notice, though, it says here, this headline says, this is from one of the local TV stations, Houston finishes 2021 with most homicides the city has seen in decades. It's up 71% in 2021 over 2019. But the number here is 470, the actual number is 473. Now, if we were to go back to, say, the 1970s and into the early 1980s, the number probably would have been almost twice that. And that wasn't just a city of Houston phenomenon. It was around the country, okay? So in the 1960s, the 1970s, you see not just the murder rate, but the crime rate just sort of growing, increasing pretty dramatically. And many Americans reached the same conclusion that some of the participants in that panel discussion reached that you watched. I don't know if you picked up on that, but there was a point in the discussion where, the moderator asked some of the participants, what's happened to crime in big cities, at least in this country, over the last 25 to 30 years, this very period that we're talking about. And many of them seem to say, well, it's out of control, right? And then when asked, what's that attributable to, at least one of them, maybe a couple of them, attributed the crime rate, the increase in crime, to the decisions of the United States Supreme Court. And I think that many Americans generally during that era would have said the same thing, like, it's because the courts are coddling criminals. Well, I mean, that's a characterization, not coddling criminals, but there really is no question that the decisions of the court during this period, as we've described them, are favorable to the rights of the accused. People in the law enforcement community may have perceived that, and American citizens more generally may have perceived that as coddling criminals, making it more difficult for the police to put the bad guys away. Well, about the beginning of the late 1980s, certainly as we get into the 1990s, the crime rate starts to drop dramatically. And so instead of 800 murders a year in Houston, now you're getting 300 or 400 murders a year in Houston for many years. Although, again, from 2019 to 2021, it increased pretty dramatically. Okay? And some might attribute that to the fact that beginning in the mid-1980s, the decisions of the court, the pendulum sort of swings back in the other direction. Because we begin to see, with that footnote that you heard on that broadcast, on that program, you get an indication that, well, maybe the court is changing its view on the exclusionary rule or on some of these other kinds of questions. And in fact, that's exactly what began to happen in the mid-1980s. That whereas in the previous era, the general drift of the court's decisions was to favor the rights of the accused, by the time we get to the mid-1980s and into the 1990s, the general drift of the court's decisions is to restrict a quote-unquote liberal application of the exclusionary rule, a more restricted application of the exclusionary rule. So that's why we need to talk about some of these exceptions to the exclusionary rule. Let me put that back up. Okay. So we don't have a whole lot of time left here, but let me at least introduce you to this first one, because this is the one that they kind of were discussing in the panel, even though the court hadn't rendered its decision in this case yet. You heard at least one or two of the panelists talk about quote unquote good faith exceptions to the exclusionary rule. So this case, U.S. versus Leon, notice it was decided in 1984. Okay? It's really one of the cases that the footnote during the closing credits was referring to. Okay. So again, there's going to be a lot of verbiage up here on the screen. Don't try to transcribe it all. Okay. Just kind of get a gist of what happened in this case. This explanation or this description of what happened in this case comes from a book called Civil Rights and Civil Liberties in the 21st Century by my old friend John Domino. He was at Sam Houston State University when I was there years ago. We had adjacent offices. We used to sit around and talk about some of these cases. So here's how he describes, my former colleague describes what happened in U.S. versus Leon. He says, although the Burger Court, by the way, that means the name Burger is Warren Burger, who was at the time Chief Justice of the United States. We talk about the Supreme Court a lot of times in connection with the Chief Justice. So anybody know who the current Chief Justice is? Who's the current Chief Justice of the United States? Does anybody know? Man's name is John Roberts. Have you heard that name before, John Roberts? So we sometimes call it the Roberts Court. Okay. Before him, the Chief Justice was a man by the name of William Rehnquist. So we refer to that as the Rehnquist Court. And before William Rehnquist, it was Warren Burger. So we call that the Burger Court. And before Warren Burger, it was Earl Warren. You know, a lot of those cases that I was referring to a moment ago that where the pendulum swung in the favor of the rights of the accused, those were decided by the Warren Court under the leadership of Chief Justice Earl Warren. Right? At any rate, here's what he says. Although the Burger Court left the exclusionary rule developed in Matt standing, it legitimized a number of important exceptions to the exclusionary rule. The most important of these came in U.S. versus Leon. Proceeding on an anonymous tip of, quote, unproved reliability, unquote, police officers began an investigation into Alberto Leon's alleged drug trafficking. A search warrant was issued after several deputy district attorneys reviewed an affidavit summarizing the officer's surveillance. The searches turned up large quantities of narcotics and drug paraphernalia. After Leon co-defendants were indicted on federal drug charges, a federal judge granted a motion to suppress evidence on the grounds that the affidavit was insufficient to establish probable cause. So remember what we said earlier. The police are surveilling a suspect and they want to search, and they go to a judge and they have to establish probable cause. And the judge has to make a determination of whether or not the information that they've provided is sufficient to establish probable cause. And what they're saying here is that the judge signed off on the warrant. The judge granted the search warrant. But then when the case went to trial, the defense attorneys introduced this motion to suppress the evidence on the grounds that the judge really should not have signed off on the warrant because the evidence in the affidavit does not meet the standards. Whatever those standards were, did not meet the standards for establishing probable cause. That make sense? That's the basis of their argument. And the trial judge, not the same judge who issued the warrant, but the judge who's presiding over the trial, agrees and suppresses the evidence and says this evidence that the police obtained from serving this warrant is not going to be introduced at trial. But then the government appealed, okay? And then on appeal, the United States Supreme Court says, well, the evidence doesn't necessarily have to be suppressed. And in fact, in this case, it shouldn't be suppressed. Why? Well, because it's not the police officers who made the mistake. It's the judge who made the mistake. In other words, the police believed that they were serving a valid search warrant when they conducted that search. And the whole purpose of the exclusionary rule, they say, is to prevent the police from conducting unreasonable searches. If the police believed that they had followed due process and that they were serving a valid warrant, the evidence should not be suppressed at trial. So this is the first very important exception to the exclusionary rule where in the previous period up until the mid-1980s, it was an automatic thing. It was automatic. It was a prophylactic rule that if there was some problem with the warrant, and certainly this would qualify as a problem with the warrant, it automatically, and you heard the participants in that program, even the ones who disagreed with it, pretty much agreed that that was the current, at that time, the current state of the law. They all pretty much agreed. Of course, it's going to be suppressed. All right? But this case changes things in a big way. Now, there's some other ones that we're going to talk about in the Thursday class meeting, but you'll have to pick that up from the recorded session, okay, because we're just out of time. There's lots of interesting stuff that we're going to talk about in that Thursday class session. All right? We'll see you in 1 week.